Good afternoon, everyone. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. And I just want to welcome everybody for joining in our CLE today on drafting wills and powers of attorney. For those of you that are not familiar with our program, the Dallas Volunteer Attorney Program, or DVAP for short, is a joint program with Legal Aid of Northwest Texas and the Dallas Bar. And our primary mission is to match low-income Dallas residents with private attorneys that will do their case pro bono. We handle a wide range of civil issues, and one of our common issues are drafting wills and powers of attorney for our clients. It's actually probably one of the easiest ways to get involved in doing pro bono work. It's transactional, it's only takes a few hours of your time, and the benefits are very rewarding. So today we have Brandy Baxter Thompson to speak to us about how to do the wills and powers of attorney. Brandy is a partner at Lawn Smith, Soslick, Baxter Thompson, and Johnston. She is board certified in estate planning and probate law. She has been named a super lawyer since 2017 and every year since, and was a rising star before that. In 2019, she was awarded the Nikki DeShazo Pro Bono Award by the Dallas Bar Probate Section. And in 2018, she was awarded the DVAP Ken Fuller Outstanding Mentor Attorney Award. She's a frequent speaker on estate planning and probate issues. And she's going to talk to us today about the wills and powers of attorney. And if you have questions, feel free to use the Q&A section at the bottom of your screen. And if there's time at the end, we'll try to get to those. But without further ado, I'll turn it over to Brandy to tell you all about how to do wills and powers of attorney.
Thanks so much, Kristen. I am going to mark my timer at 45 minutes so that we'll leave some time for Q&A. And I thank you so much for that introduction. And it's always a pleasure to speak and assist the DVAP program. And I'll just echo Kristen's comments. It's a great way to get your feet wet in this area, and to have a mentor, somebody that can assist you to learn how to do this, prepare documents, and even work in the probate, guardianship, heirship arena as well. So I have a PowerPoint presentation that I'm going to share, and then I'll walk through that with you. It's my understanding that DVAP will also provide this PowerPoint to you for your reference in the future. And again, if you've got questions during the course of my speech, please feel free to put your questions in the Q&A, and we'll look at those at the end of this talk today. All right, so we are going to address basics of drafting wills and powers of attorney. I'm going to first take a look at this question of who is your client. That may seem like a very ordinary question, but it's this area of practice is really an area that you see a lot of elder exploitation and influence issues. And we as attorneys have, an opportunity and a duty to make sure that we're not going to be party to something that would be considered elder exploitation or undue influence. And sometimes it comes in the form of a family member or friend that is, trying to be very kind and assisting to the elderly person if the person is elderly. But, we need to make sure that we scratch below the surface and take a look at some of these issues. And the first is, is the person that's reaching out to you not the client, the person that would be signing the documents? Is that person a potential beneficiary? is the change that's being requested, if there are changes made, or the documents that are going to be prepared, going to substantially benefit the person that's calling you. um, you know those are all things to take a look at. Make sure that you have a meeting and speak with the client directly, without anyone else present. If you have any concerns about their capacity, ask them some questions, open-ended questions. And some of the information that you're going to be gathering, that we're going to discuss here in a minute, is a really great opportunity to make sure that the client does have capacity. If you have concerns about that, then you definitely don't want to assist in preparing a document that is going to be subject to challenge later on. Um, if and even if the person does have capacity, and what they're preparing you feel very confident is what they want, you are carrying out their wishes, um, assist them in making sure the documents are impermeable. Make sure that nobody else is present in the meetings with the client. Um, Make sure that you don't use witnesses or a notary other than who you provide. Um, and if you do suspect any kind of exploitation, you should either report that to APS, or if there's an incapacity issue and you think there's an exploitation going on, you might even want to consider making a referral to the court investigator's office. Um, when we have a married couple come to us to ask to prepare estate planning and documents, you want to make sure that you explain to them that you're going to be representing them jointly, and that they will need to sign a waiver of conflict. And I would always include that in your engagement letter. Um, just because they're married doesn't mean that there's not a conflict of interest. And be on the lookout for some things that may come up. If they have fairly different estate plans, that can be a little bit of an issue, especially if they're wanting to make changes to their plan and not have the other person know about it. Most married couples that come to you and ask for you to prepare their documents, there's not going to be a conflict. There never will be a conflict, but it's just something to kind of bear in mind. Also, with respect to married couples, you want to make sure that you have any premarital or partition agreements from them. You may need to be updating those documents. I've had occasion where they've wanted to rescind a prenuptial agreement, or fine tune the partition agreement. Obviously, that's a little bit beyond what we're going to talk about today, but that's something that you need to talk about with the client. And a lot of times we have a blended family situation. That's going to also necessitate obtaining any prior divorce decrees, or other records that you may need to consider in how the documents that you're preparing need to be fashioned. So I like to add a little bit of levity to this. I love little cartoons like this, and this one is it's kind of funny. It's a little less amusing when you hear your kids calling it the death tax. And notably, we are not going to talk about the death tax. We're not going to talk about taxes at all in respect of estate planning. That is well beyond basics. And if you find yourself in a situation where the client is in need of some tax planning, and it's outside of the scope of your expertise, I would very much caution you from engaging that client, and refer them to somebody else. If it's something that you're interested in, definitely see if you can get the assistance of an experienced tax lawyer, estate planning lawyer to prepare those documents. It's not, I wouldn't say frequent at this point. I definitely think the door is opening a little bit further and further for malpractice suits in respect of estate plans. So we definitely don't want to go beyond what we're we're really capable of doing. And right now, the plan, the estate tax exemption is $11.7 million. There's, of course, there's talk in Congress of a plan to bring it back down to, or bring it down to $3.5 million. Nobody really knows where that's going to end up landing. But I would say that it's safe to say that the vast majority of people, and obviously anybody coming through DVAP, is not going to have a tax issue that you're going to have to address. So the basics in preparing wills are, gathering the information from the client. And there is a lot of information gathering, family, assets, debts. I'm going to go through various points of discussion that you'll need to have with the client. And then I'll talk about the specific, technical formation requirements in order to make a will. So obviously you want to know about their family, and not just the people that they want to leave the assets to, kind of cast the net wide and ask about, not just the spouse and the children and grandchildren. And I should add on here, actually, finding out about their parents, and if they're deceased, do they have any siblings? This is going to kind of inform you with respect to potential heirship issue. And I'll discuss that a little bit farther down the road, but just note that, in wills, sometimes they include a statement at the end where if all the persons that I've identified as beneficiaries are deceased, then it should pass to my heirs at law. And if I particularly don't like that kind of language in there, just because, if you've got somebody that doesn't have a lot of family, particularly, their parents are deceased, they don't have any siblings, that could run into an heirship proceeding that could be well beyond what anyone would have imagined. But obviously, of course, the basics, ask for information about their current, were they married? Have they had any divorces? Who are their children? Are they minors, special needs? Are there any stepchildren or adopted children, or children that people that they would want to be considered as their children? Not just their blood children, but there may be other people that they want to have. And I've seen that in a lot of wills, especially with a stepchild that may have never been formally adopted, but they consider that person to be their child and they would like to have them treated as such. That, of course, would have to be specifically, or you would want to specifically identify that in the will. And the same for grandchildren. We want to know if there's any minors or children with grandchildren with special needs. We don't want to be leaving gifts to anyone that's going to result in them being disqualified for any benefits that they may be receiving. And just as important as identifying, the people that they love, also the people that they are, on the outs with, and any estranged children or grandchildren. We operate in a polite society, and we wouldn't necessarily ask questions like this if we were just meeting somebody for the first time. But when we're in this relationship with somebody, we have to ask these, seemingly difficult questions and dig into whether anybody that that they have in their family has, do they have any mental illness problems or drug problems? They may not consider them special needs, but those are definitely issues that we want to consider, and making sure that we're not, leaving assets to somebody that's just going to, be a disservice to them. And also making sure that you identify all of their children, even the ones that they're estranged from, and especially if they are not going to provide for them. I had one situation myself where I had met with the client and prepared a will for them. And it was actually when we were getting ready to sign the document that it came up somehow that she had this other child, and she never spoke of this child. I asked her who her children were. She never identified this person. And, it put a halt to everything we were doing. So, making sure that you're being creative in your questions too, and making them open-ended and kind of coming at it from various directions is another way to make sure you gather all the information that you're going to need. With respect to gifts to classes, I've kind of talked about minors and special needs, but with gifts to classes, you want to identify all the persons in the class. You don't want to have a will that leaves it all to nieces and nephews without identifying who those persons are. That very likely will result in the need to have an heirship proceeding to determine who their nieces and nephews are. And I was involved in an heirship where that was exactly the case. The person had a nice will, it was proper, it was valid, it was original, but they left it to a class of persons that weren't named in the will, and we had to go through this very taxing and cumbersome heirship proceeding because this person had like 8 siblings. They were very elderly when they died. Most of their siblings were deceased, and then they all had multiple children, and it was just a little bit of a mess. And a careful estate planner could have avoided all of that by identifying who those persons were. Charities are, frequently given gifts and wills, and the best thing that you can do is just making sure that the name is proper. You may even need to contact that particular charity and being specific. Sometimes people will say, well, I want to leave it to the SPCA. Well, is it the ASPCA? Is it the SPCA of North Texas? Make sure that you have the specific entity that they want. And sometimes the name that you and I know it by is not the name that they have, that they would like it to be made payable to, or to be included in a will. And of course, as I mentioned, you want to identify any estranged children or grandchildren. So now that you have identified all of the family members and persons that are potentially going to be beneficiaries, we want to look at what are their assets. Do they own any real property? Is there anything outside of Texas? And make sure that they understand that oil and gas, mineral interests, those are considered real property. And if they're outside of Texas, you definitely want to know that. To me, this is one of the fun parts, is to talking to somebody about, their stuff and what things they may have collected or things that would be, valuable, not just monetarily, but, emotionally valuable to them. And, making sure that those things are, accounted for and given to somebody that they think will take care of them. They may even want to consider leaving certain collections to an entity, a museum, etc. That's not something that we run across very frequently, but when it does, it's something, it's kind of a fun discussion to have with the client. We also want to, of course, identify, where do they have any cash and securities? What are their bank accounts, their IRAs, their 401ks, brokerage accounts? Do they have a safe deposit box? You definitely want to ask them what is in the box, and they may want to include a handwritten inventory with their documents so that when they're gone, the person knows what is in that box and what needs to be done to get into that box. And lastly, identifying if they have any interest in any privately held entities such as LLCs and FLPs is going to be really important. So some of the considerations that you'll want to discuss with the client is, if they do have any property that's outside of Texas, and again, this is a little bit outside of the scope of what we're talking about today, but having those assets put into a trust, is extremely important, and it will avoid a lot of expense on the back end. Any real property they own is going to require, outside of Texas, is going to require probate in that state. They may not care. They may not want to go through the trouble of preparing a trust and transferring it into that. But I think, it's our duty to make sure they understand what is going to be required upon their death for those assets to be transferred. You also want to make sure you note whether the property is co-owned and with whom, identifying their oil and gas interests, if any, and explaining the homestead rights of the spouse. There's so many assumptions that people make based on, I don't know, rumor or what they've heard. And sometimes what they've heard is from a different state. So in Texas, they need to understand that this house may be your separate property, but when you pass away, your spouse, even if you give that house to somebody else, is going to have a homestead right in that property. Um, they need to understand that that's an inviolate right of the surviving spouse. Our most common specific bequests are, of course, going to be tangible personal property or cash. Um, you'll want to make sure that you get very specific information. And sometimes it's worth it to have them take pictures and put together, a little, you know, document that has the different items that they want to go to certain people, or if they just want it to all of my personal property to go to my children equally. Um, Another consideration is to talk about how they want that divided. Um, I've had some clients come up with the most elaborate schemes to have the personal property distributed between their children, and others it's very very bland and simple, and they just really just leave it up to the executor. With any of the accounts that they've provided you information about, you want to make sure that they uh, tell you whether they're a survivorship account, a payable on death, or have some other beneficiary designation attached. And this is an opportunity to go through an explanation of what is a probate asset versus a non-probate asset. And I always have that talk with clients. They it's very easy to explain, that everything we own is going to be put in one of two buckets. It's either a probate asset or it's a non-probate asset. And that the probate assets are going to pass according to what the will says, and the non-probate assets are going to pass according to typically this contract, a life insurance policy, beneficiary designation, etc. And that becomes really important when you look at how they want their plan to be prepared. If they have a specific bequest to a niece of $100,000, but all of their bank accounts and retirement accounts are going to be payable on death, or beneficiary designations go to another niece or a child, then there's not going to be enough cash for that gift to be made. And they need to, so you have to really take a holistic view of their assets to see what exactly do they have, and how is it passing now, and they may need to make some changes in order to accomplish those goals. With a safe deposit box, this can be the bane of the executor or the attorney representing the executor, especially when the original will is located in it. Of course, there are provisions in the code that allow a court order to gain entry into that box. And despite how it is described in the code, it is sometimes a very difficult ordeal and can cost a significant amount of money. A year ago, we were involved in a case where it took about 4 or 5 months to get into the box, and it took going to court 3 different times to get a bank in Dallas to open the box, and it was quite the ordeal and cost a substantial amount of money. So you want to make sure that that they have the keys, and that they are in a location that is going to be easily accessible to whomever is going to need them. And then also note that they can add somebody to that box to enter the box, that not necessarily is going to have ownership of the box upon their death, but will be able to enter it after they die. With respect to privately held entities, you just want to gather as much information as you can and take a look at these formation documents in particular, because there may be provisions in there that say that the other owners can buy the decedent's interest out. If it's a business that's being run, is that surviving spouse going to have the right to, retain their husband's or wife's interest in the company? Will they be able to, get their own appraisal of what the value is, or are they going to be stuck with what the other partners come up with? This is a really important a point to go over with the client and make sure they understand everything, and particularly when you're representing a couple, so that the surviving spouse, who's obviously they don't know who's going to be the surviving spouse, but that both spouses, the spouse that is not the owner per se, is going to understand what their options are. Next, of course, you want to identify who the beneficiaries are. We know who all the, we know the family, we know, the assets. Who do they want to leave that to? Family, friends, charities. And then I'm a huge pet lover, animal lover. I always make sure I have that, have that discussion with the client to make sure, do they have a pet that they need to have, something set up as to who's going to take care of that pet. Another little funny, everything I have, son, I have because your grandfather left it to me. I see now that that was a bad thing. So informing this son that he's not going to inherit everything that he thought he was going to inherit. I thought that was kind of cute. So other information to gather, trusts, if there's any trust that this person created, if they're the beneficiary of, you want to look through those trusts, understand if they have any power of appointment. Do they understand what that means? You need to be able to explain that to them if they don't, and make sure that that's addressed in their will or otherwise. As I mentioned in the beginning, if there's any partition or premarital agreements, you definitely want to have a look at those. And then our companion animals, it's definitely lots of questions that you can ask about this. What kind of pets do they have? I had one situation where this woman had two macaws, and they were definitely needed to be provided for. She loved these birds, and they were her pride and joy, and she made very specific provisions for those birds. It's a little bit unusual. Most people have either cats or dogs, but there's definitely some things you can do in the will to leave a certain amount of money to a person, or to leave the executor with the authority to appoint somebody, or to find somebody to take care of the animal. There's just a lot of different considerations to take. And of course, you want to discuss who do they want to have as their executor, the trustee, understanding, that this person is someone that's going to be, charged with the duty and responsibility of collecting their assets, paying their debts, and then distributing per the will, and that it is not a job that is easy or simple. It can be rather contentious depending on who the beneficiaries are, and also having to ask the question about the executor's qualifications. Making sure that that person's never been convicted of a felony or had any other issues. You might even just run the person's name yourself through different databases if you find that if you're not able to get that information from the client. But you definitely should explain to them that what the qualifications are going to be for that person. Obviously, you want to talk about specific bequests, and then that contingent disposition. When discussing the executor, you always want to have them list a couple of alternates in addition to the person that they want to have named, explaining the pros and cons of co-executors, and encouraging the client to discuss this appointment with whoever they're wanting to serve as the executor. Another kind of thorny issue can be discussing executor compensation. Sometimes people ask me, well, frequently actually, they ask me, what do other people do? And I just, I kind of turn it back on them and say, this is a real personal choice. And I explain to them, because I've done the job myself as an administrator, that this is not an easy task. It's a lot of work, takes a lot of time. Some people have very strong opinions that nobody should be paid, especially when they are one of the beneficiaries. If they're, they have 3 children and one of the children is the executor, they don't want them to seem like they're getting something more than the others. But again, just making sure if they do want to have compensation, that it's provided for in a pretty specific way, and that it is actually included in the will. You want to, again, as I mentioned earlier, kind of go through the technicalities of how they want to distribute this tangible personal property and discuss some various options with them. Um, most wills aren't going to create a trust, a testamentary trust, but if they do, if you have, some wills, or some people have in their forms, no matter what, they have this contingent trust for a minor incapacitated person, so that if, the person that they're leaving the money to today may be fine, but if they're involved in a car accident in the future and they become incapacitated, and they're on some sort of governmental assistance, you don't want them to be disqualified. So a lot of times people will have these contingent trusts in there, so they need to have, who would be the trustee, and that sometimes requires some kind of really creative thinking, because a lot of, sometimes the person that they would want to be the trustee is a person that may be incapacitated, so they got to really kind of think outside the box and talk about, compensation and whether they want the trustee to have a bond in place, especially if there's going to be a small amount of money. If the person's a minor, then that's a little bit different. You can definitely have the minor's parent, or maybe even a sibling, be the trustee when it's a small amount of money. But when we're talking about a substantial amount of money, they may want to have the discussion with them about corporate trustees. With specific bequests, a lot of times people will, like I said, they'll just say, I want everything to go to my kids equally. But then I always have a language in my will that provides for a memorandum and allows them to attach some handwritten list of their personal property that they want to give. Some people will put sticky notes behind the painting, or the particular book or whatever they want to pass to somebody. But I think it's really better to have some sort of a handwritten list, or even better, pictures. And then that's specifically when it comes to jewelry, you definitely want the jewelry to be very specifically identified. And I think the best way to do that is with a photo. As I mentioned earlier, the idea of this contingent disposition, I am not a fan of including language that just everything passes according to my heirs as they're determined under the laws of intestacy in the state of Texas. The whole reason we have a will is to avoid having to go through heirship. And by, I think, putting this language in there, you're just setting them up to have that happen if all the people die. And I've seen that happen. I mean, it's, especially if somebody lives a long time and everybody that they've named is gone, which a lot of times you don't necessarily intend, and they can't foresee that. But we always want to try to avoid that. So, talk to them about having, a charity or an alma mater identified as a, the gift of last resort. Some people may even, want to set up a foundation, and that sounds like they need millions of dollars, but there's definitely people that will put together, a foundation account for a lot less than that, 50,000 or 100,000 or whatever. And so they've got that set up. They may want to leave the rest if there's anything left to that. Let's talk about will requirements. Who can execute a will? Well, you just need to be over the age of 18, of sound mind, and make sure that it's properly executed. It's the threshold for creating a will in Texas is very low. We've all attended the wills and trust class in law school, where the guy left the inscription on the bumper that he was trapped under, or just a simple piece of paper. I actually probated a will earlier this year that was a doctor that had a pad of paper with his name on it, and he just said, I leave all of my estate to my wife, and signed it, and that was it. And we probated it, and it was a valid will. So it's pretty low threshold. It of course has to be in writing. We don't allow for an uncupative will anymore in the state of Texas. It can be wholly in their handwriting and just signed, or if it's a typed document, it needs to have a couple of witnesses, and those witnesses must be over the age of 14, and they subscribe their names to the will in their own handwriting in the testator's presence. A holographic will is written wholly in the testator's handwriting. Doesn't require any witnesses or notarization. And then the self-proved will allows for our very simple probate process in Texas. There's a self-proving affidavit that you can attach to the document, and it can actually be attached later on, not just at the time that the will is executed. It can be later self-proved. And then there is this provision now in the code for a simultaneous execution, attestation, and self-proving. So, a lot of some people still like to have that separate self-proving affidavit. Others do it all in the in the same time in the same document, and the language is in the state's code that that you can track for that. All right, requirements for self-proving affidavit. Again, just requires the will be signed by the testator and the witnesses, and then the self-proving affidavit is a separate form that has to be, again, signed by the testator and the witnesses and notarized. This self-proving affidavit allows us to prove up the will without having any of the witnesses present. Again, I tell people, and we have so many people moving here from other states that don't understand, just really how simple probate can be in Texas. And the self-proving affidavit is really kind of the device that allows it to be so simple. As I mentioned, we've got this alternative now with the simultaneous execution, attestation, and self-proving language. A will does not have to designate an executor, but it can simply just appoint an executor, which is kind of interesting. You don't really see that very often, but it can. The code does specifically require that. Allow for that. If you want it to have an independent administration, these magic words must be in the will. Most people obviously want to have an independent administration. They don't want to go through the expense and heartache of dealing with a dependent administration. So make sure you have this in there. And of course, some various points to remember in drafting, identifying all the family members, even those that are not receiving any gifts. I always, as I mentioned, include dates of birth for children. Do not put any social security numbers. Every once in a while you'll run across a will that has a social security number. I don't think that's a common practice anymore. Definitely not something I would recommend. And then even if they're not leaving anything to grandchildren, I would identify them if they have children and that child, if upon that child's death it would pass to that child's children, their grandchildren, you definitely want to identify them as well, even if they're not receiving at the time. Some various other considerations, giving the executor the authority to make a non-pro rata distribution of tangible personal property can alleviate some issues and give them the authority to, make it a little bit easier. I always include a definition of incapacity and the power of sale. If you don't have that in the will, then you can ask the court to include it. But I just, to me, it's just so much easier just to have that language in there. Codicils are amendments to the will. They republish the will and can be done just to address various simple changes that need to be made. A lot of times if, the person wants to change who the executors are, or they want to rewrite a couple of, maybe a small specific bequest, they want to change the dollar figures or change who's receiving them. Sometimes it's just easier to do a codicil. But remember, a codicil must be executed in the same manner in which a will is. So it's going to require it be either wholly in their handwriting, or if it's a prepared document, they have to sign it before witnesses. And it's always best, of course, to have it with a self-proving affidavit as well. in reviewing this, I ran across this slide, and I thought maybe I should take this COVID-19 out, and I would love to say that we don't have to deal with this anymore. And I think we're definitely heading in that direction. But I think it's definitely good, practice, to have, sanitization in our offices on a regular basis, especially not even with COVID-19 anymore, with, flu season and things like that. Just kind of making sure that you're thinking about those kinds of things. The remote notary, who knows if we'll be able to continue doing that in the future, but just note that that really doesn't help us with a will. The will has to have witnesses. I know a lot of my partners, when COVID first hit and they had clients, screaming about what to do, they were redoing their documents and they were just having them, handwrite something. Obviously, no witnesses, no notary that's required for that. And one other thing to note is, for trust, they're not going to require any witnesses or notaries. So if you're in a real tight spot with a client and you just need to get them the document and they can print it off and sign it, it's valid. It's not optimal, but it's definitely, if you're in a pinch, something that you can do. So now we'll turn to powers of attorney. Slip in another funny here. So at their, clearly they've asked this lawyer, what's his superpower? Well, I was bitten by a radioactive lawyer and ended up with the power of attorney. Yeah, it's a funny lawyer joke there, but powers of attorney are the very powerful documents. And I think, really requires us to explain to the client exactly what they're doing and giving this person the authority to manage their affairs. And they're excellent when, you want to avoid a guardianship, and we all want to make sure our clients don't ever end up having to deal with a guardianship situation. And these are definitely the best documents to assist with, financial matters. The code defines powers of attorney for us and does actually include the specific form that we can use. And this is a form that's been vetted and gone through with banks, et cetera, to try to come up with something that's going to be acceptable to those financial institutions. You want to make sure that you explain, what exactly is this role that they're, appointing somebody to take on as their agent or attorney. In fact, they're, want to think about, is this somebody that they would want to give all of their assets to be in control of right this minute? And if they balk at that, you want to have a discussion about that, because this person, if they become incapacitated and it's effective upon their incapacity, they will have that authority. Again, just as with an executor, always make sure you name at least one alternate, maybe a couple of alternates. The form provides for granting single or multiple powers. At the very end, of course, there's the O, where you can give the person that's named as the agent all of the powers above. Sometimes clients come in and they just need something, for a particular transaction, so you can definitely tailor it for that. Most of the powers of attorney I've ever created have been pretty general, and allowed for all the powers to the other person, to the agent. We do have a section in the form that you'll see in the estates code that provides for compensation and reimbursement. Go through whether they want the person to have compensation. Do they want to be, make sure they're reimbursed? I think the language in there doesn't necessarily address how the compensation is calculated. I would, encourage people to include language regarding what is reasonable compensation. Powers of attorney do authorize persons to make gifts on behalf of the principal. This is particularly important with somebody who's, been in the process of making gifts to reduce their estate, or if they just, maybe they have, grandchildren or persons that they feel very strongly about making sure that they get a gift every year. You want to talk to them about that. They may have some very specific, language they want to include, like that it can't exceed the annual exclusion amount, or maybe it's a certain dollar amount or a certain time of year that they want to make sure that that gift is made even once they become incapacitated. The springing power of attorney is one that comes into life in effect at a later date, and typically when the person becomes incapacitated or is incapable of making their, managing their financial affairs, which is based on frequently, having a doctor declare that they can't manage their affairs anymore. If you do have a springing power of attorney, I would encourage you to have the client also have a Hipaa release done that allows the agent to obtain that medical information. If, again, if they don't trust that agent now, then they should definitely consider a different agent. The other thing too is explaining the pros and cons of a springing power of attorney. Sometimes the springing powers of attorney are difficult to, get a bank to accept. I think some banks are better than others. It's just, something that you want to have a discussion with the client about. And the final thoughts here, ask lots of questions, and make sure that your questions are frequently open-ended and not assuming things, especially with an older person. We have a tendency to want to help people and kind of fill in their thoughts, and it's really better to make sure that those questions are open-ended, and allow them to fill in the blanks and just sit and listen sometimes. Confirm everything that you're receiving through some sort of documentation. And obviously, we're counselors, attorneys and counselors. And so, this is really a great opportunity for us to engage in that counseling with people. They frequently want to know what we think and what others have done. And, you can give them, war stories, or, have various scenarios that you want to, share with them about things you've seen, and give them the opportunity to think about it. Be very wary of people that are trying to help, especially when that helper is going to substantially benefit from the documents that you're preparing, and always retain copies. The practice in my office is we retain the originals so that they can be scanned, and then we bind them and provide them with a copy and a thumb drive of the documents, so that they can easily send them out to other people. So thank you so much for the opportunity to, speak with you today. It looks like we've got a few Q&As, so let's see if there's anything. The course number, I think that's going to be posted. Is it better to create a trust instead of a will? What level of income would you recommend a trust for instead of a will? Well, I would never, ever, ever have a trust instead of a will. I would probably err on the side of having a will and always trying to have a revocable trust versus never having a will, because people will always have something, something that comes up where they need, they have a probate asset that needs to be collected, or somebody that needs to be appointed to go address an issue, maybe a lawsuit or whatever. So it's always better, I think, to have the will and then maybe later have a trust. And as far as the income with respect to a trust, that's definitely a consideration. And I don't know that I could put a number to that. It's something that you just have to think about. If it's a small amount, who's going to be the trustee? If it's a substantial asset, then, maybe it's a good substantial estate, excuse me, maybe it is a good thing to have a trust if they want to preserve who receives the assets upon, maybe their spouse's death. And, that's something that we come up with in blended families a lot, where, two people are married, they've been married a long time, but they have children from different marriages, and they don't want to leave everything to the spouse, and then the spouse give everything to the spouse's children, the surviving spouse's children, and not their children. So, the best way to do that is have everything go into a trust that then is for the benefit of the spouse during that spouse's lifetime, and then passes to their children upon their surviving spouse's death. Um, the next question is, you might address the issue of co-executors. This sounds great to some people with multiple children who, but can end up creating a lot of problems for administration of the estate. And I completely agree. I personally try to discourage co-executors, and I think sometimes people are adamant. I've talked with friends and that have, other probate lawyers that have said they've dealt with, for having four, co-executors. That's just, it's extremely cumbersome. All of them have to sign off on the inventory. They don't necessarily all have to be in the hearing, but it's probably the better practice to have them attend the hearing. You also want to make sure that you kind of address this issue of how are we going to, have a deciding vote if you do have co-executors if they don't agree on something. The Texas statute for the power of attorney form, I believe that's in the PowerPoint. I don't know that code section off the top of my head. It's near the back of the estates code. In fact, let me just see if I can find it really quickly for you. If you look at subtitle P, that's the durable powers of attorney that starts at 751.001. The statutory durable power of attorney form is 752.051. That's a great question. Do you use a web portal for clients to enter data that will be used to build the documents, or you just write it down when interviewing them? So I actually have a form that I send to the clients that, and I tailor it. I have, one for single people, one for married couples, and then I have a form that's for, a simple estate, because when you first talk to the person, you kind of get a sense of what their assets are. And if you sense that this is a pretty small estate, I send them a more simple document. If it's somebody that clearly has a little bit more sophisticated assets, I have a lengthier document. And one thing that I did not include, and I apologize, is also asking them about debts too. They may, most people, understand that their debts are going to be paid at their death, but it's definitely good to walk through that with them and make sure that they understand, hey, this house may be worth $1 million, but if it's got $850,000 worth of debt, the net is going to be pretty small. It's obviously smaller than the value of the house, and that's how that's going to be divvied up. So looking at the net, and then looking at, do they have any personal guarantees or other, debts, especially somebody that's been involved in running businesses, and how is that going to be impacting, their estate when they pass away? The next question, how do you create a trust for out-of-state real estate? So what I do is I prepare just a simple revocable trust, Texas revocable trust. It just has to have a deed that transfers the asset to that trust. And the best practice, of course, is to find an attorney in that location, in that state, that can prepare the deed and get it recorded. The deed would, if they own, let's say they own a second home in Colorado, then they would, have a deed recorded that transfers that from them individually to themselves as the trustee of their trust, and that would put it into the trust. Next question, could you give us a few examples of common mistakes a new lawyer may make in will drafting? Common mistakes, I would say, I think I discussed several things that I think come up a lot. Probably not identifying the family properly, or to the extent that you really need to avoid an intestacy at some point. I think not getting enough information about the assets and making sure that they understand the difference between probate and non-probate assets and how they want their assets to pass. I actually had a gentleman with a pretty sizable estate come to me to revise some documents. And it was clear in looking at his original documents that he had a will that left his assets to, a particular person, but then no, this is what it was. He wanted his wife to be able to have access to all of the money, and then upon her death, for it to pass to his children. And just the way that the way that the will was set up, it had a trust that would accomplish that goal, but he had all of the assets passing to his spouse, through beneficiary designations. And so I had to explain to him, this will's great and this trust would be a valid trust, but you have left her everything individually, and that means that she's going to have those assets to be able to use and spend and do with what she wants, and your children may never see any of that. So I think that's another mistake. I think you just really have to be, very inquisitive and curious with the client, and be willing to ask questions that are hard or difficult. That's our job. Can you allow the executor to appoint a successor executor if they don't want to serve, or must the court do that? That's a great question. I think I have that in the PowerPoint, so you can look at that. There was a revision to the Estates Code a few years ago that allows for the testator to name somebody for the specific purpose of appointing a successor executor. So yes, that is allowed. Obviously, I would try to avoid having the court do that for you, because they may appoint somebody that, if nobody can agree, then they may end up appointing, having to appoint a dependent administrator or executor. The next question, thoughts on incentive provisions for living revocable trusts? I'm not sure I understand that question. If you could maybe clarify that for me, or give me a little bit more information. Could you waive the affidavit in lieu of returns in the will? I'm not sure I understand that question either. I'm sorry. Are you asking, can you? I don't think that you can waive an affidavit in lieu or um, an inventory. That's required by statute. And that's beyond the scope of what we're talking about today. But make sure that if they do want to have an affidavit in lieu in an estate, that they do it within the 90 days. We just have one kicked back for that reason. I don't know if you're talking about with incentive provisions, as far as like having incentives for somebody to do certain acts in order to receive a distribution, if that's what you're talking about. I would say, if you have a trust, most people would specifically, maybe have provisions of wanting, when the person to be able to support themselves, and that the distribution can only be for their health, education, maintenance, and support. If sometimes people create trusts for people that are, have a drug problem, or have had mental health issues, etc. Maybe they have some provisions, that they have to jump through certain hoops in order to get a distribution. Perhaps that's what you're referring to. And I see that there's a few things in the chat. Let me just look real quick and see. Okay, what are some of the best tools to utilize in drafting the will? Well, if you take a case through DVAP, they have forms for you. There are also some really excellent CLE that the State Bar puts on. There's building blocks of wills that is put on every year. I think it's usually done in February. It's not a live course. It's all done virtually, and has always been that way. They usually have a lot of CLE documents that have forms. There's also, it's an advanced course, but there is an advanced estate planning and probate drafting course that you can attend, where you can get obtain some forms too. And if you're a member of the College of the State Bar, you can get a free membership to the online library, which allows you to have access to a lot of old CLEs and look for some forms that way as well. All right. And me just make sure there weren't any. Okay, we'll do this last question and then we'll shut it down. To what extent are beneficiaries made aware of what others receive under the will? Well, a will, once probated, is a public record, and anybody can go and obtain a copy of that will to see. Additionally, you're required by law to provide a copy of the will to all of the beneficiaries, which means they will see what the others are receiving. There are some very tight restrictions that allow for not providing them with a copy of the will, but I think best practice is always to send the copy of the will to all of the beneficiaries. Thank you so much. Those were awesome questions, and I appreciate everybody's attention and time today. And I hope this has been a help. And if you have any other questions that you think of, my email is in the PowerPoint presentation. It's brandy@lss.legal. It's not a .com, it's .legal. I'm happy to answer any questions, or feel free to give me a call as well. Thanks.